I am Shrirupa Saxena, Tax and Regulatory Partner with Grant Thornton. I'll be your moderator for today's session, Overseas Investments into FEMA, under FEMA, Practical Insights onto the One-Time Regulatory Window. A very warm welcome to all of you. Thank you for joining in. We are delighted to see such strong interest. Just as a context to our discussion ahead, as per DPIIT, Department of Promotion of Industry and Internal Trade, since 2000, India has invested over 700 billion USD as outbound investment. That's a significant figure. And with that scale comes complexities. Managing and adhering compliance to regulations can often be a challenge, especially when the investments have been made several years ago. There are multiple structures involved. There are multiple jurisdictions involved. Aligning overseas teams to actually report according to the Indian regulations may be a very difficult task in managing within so many outbound investments. In my 20 years of experience, I have often seen that even small oversights can cause delays and impact transactions. In fact, they can prove to be showstoppers for transactions. This is why our today's discussion is particularly relevant. As you would recall, in August 22, the regulators revamped the entire outbound investment framework. They brought in a concept of late submission fee, or LSF. LSF basically is a mechanism through which one can pay a fee for regularizing past compliances without undergoing a compounding process. Now, there is a catch to it. The LSF can actually be paid only up to 3 years. So for compliances which were prior to introduction of this regulation, say August 22, prior to August 22, when these regulations were introduced, the window to regularize through the LSF mechanism is available only up to 21st August 2025, around a month and a half. Now, if the non-compliances for that period are not regularized through the LSF route, then we have to do it through the compounding mechanism. And if those issues are not resolved, either through the LSF route or through the compounding route, then the overseas investments may get restricted. It could happen that we may not be able to make any acquisitions, new investments, any new incorporation, or even disinvestments. So the ramifications are very significant. We will discuss this in much more detail and depth during the course of our panel discussions. But essentially, there is a call to action now. And what we have designed in this session is a framework for you to understand how best to navigate this situation. Here's how we have planned today's discussion. We will begin with a short presentation covering the ODI regulations. This is just to set the context for the panel discussion. Following the presentation, there will be an interactive panel discussion in which we will cover the common pitfalls, the regulatory nuances, and also the practical strategies to tackle non-compliances that may have surfaced. We also have a 10-minute Q&A session at the end of the session, and you can post in your questions in the Q&A box. We will try to address as many as we can during the course of our webinar. With that, let me introduce our panel today. We have on our panel Suhas Bendre. Suhas has more than 20 years of experience in dealing with complex FEMA regulations at an MNC bank. He brings in practical solution-oriented insights while dealing with FEMA issues. He is a chartered accountant by profession. We are also joined by Shrikant Dadiparthi, Vice President and Head Capital Account Business at Axis Bank. Shrikant has been with Axis Bank for more than 2 decades now. He specializes in FEMA and is also known for his deep understanding of the subject. Shrikant, we are looking forward to your AD Banker insights. We also have with us Pankaj Khadoskar. Pankaj is a chartered accountant with over 2 decades of experience in advising clients on regulatory matters. He is also part of the national leadership firm for FEMA matters in his firm. A very warm welcome to all of you. Let's get started then. Pankaj, can I please request you to provide us an overview of the regulatory framework for outbound investments?
Thanks, Shrirupa. Good evening to all. So, this slide outlines the transition from erstwhile regime dealing with the overseas investment, which was in force from 2004 onwards till August 2022. Of course, a lot of amendments were carried out as and when required by the government or the regulator. However, still it falls short of the expectation to meet the requirements of the dynamic changing world. That's where government revisited the need to revamp the whole framework, and government came out with a draft for revised overseas investment rules for public consultation. After taking into consultation public inputs on August 2022, government notified new revamped overseas investment rules, which are currently in force, dealing with all aspects of Indian investments in foreign entities. While notifying the new set of rules, a lot of practical aspects were taken into consideration in order to simplify the whole regime, as well as to take care of ease of doing business. Some of the concepts which were not there in the erstwhile regulation, like control or strategic sector or overseas portfolio investments, were brought in the regulation, assigning a clear-cut meaning to that for the first time. Just to give an example, a term net worth has been defined to carry same meaning as it carries under the Companies Act, and to make the life simpler by not having different meaning for different statutes. This actually help the businesses to run their business and plan their affairs more efficiently. Next slide. Overseas investments are broadly classified into two buckets: or overseas direct investments, which broadly includes acquisition of unlisted equity capital, subscriptions of memorandum and articles or chartered documents of foreign entities, in equity listed equity capital of more than 10%, or even if it is less than 10%, but with control of the overseas entity, will classify as overseas direct investment. Whereas any foreign investment which doesn't meet the test of overseas direct investment or ODI will be classified as overseas portfolio investment. Indian entity can make an ODI up to 4% of their net worth, whereas in case of an OPI, it is restricted to only 50% of the net. While the ODI requires a large number of compliances or reporting obligations to be fulfilled at the time of making investment and at a later date as well, so long as you're carrying these investments in your books, relatively there are minimal compliances with a requirement in case of an OPA. Next slide. In the revised framework or new OI regime, as I said, a lot of terms or concepts were brought in to streamline the overall structure, such as deferred payment was allowed, swap of securities was also permitted as against swap of shares earlier. A wider meaning was given to write-off, as well as more clarity on the pricing guidelines was given. Round tripping was allowed for the first time, even though in a limited manner. Also, there is a concept of something called a strategic sector investment was brought in, so as the need for no objection certificates in case of the Indian entities which are under investigation of one or the other regulatory or investigating authorities in the country. One of the concept that was introduced in the OI regulation was late submission fees. This was introduced for the first time in 2022 rules, whereas in case of an FDI or ECB, that was already brought in earlier. So late submission fee is introduced to take care of certain administrative compliance requirements, which are reporting requirements or filing intimations with the AD Bank or RBI, and move that ahead. While such compliance or reporting requirement can be swiftly completed and matter can be put to rest by payment of fees, one really can avoid going through the long drawn compounding or adjudication process. Over to you, Shru.
Thank you, Pankaj, for that presentation. Now let's move into the panel discussion and get into some practical issues. Pankaj, my first question is to you. What are the common non-compliances that you see in your clients, both from a reporting perspective and substantive perspective? And which are of those non-compliances which can be remediated through the LSF route?
Good question, Shrupa. The violation or defaults under the OI regulation can be broadly classified as reporting violations or reporting defaults versus substantive defaults. The reporting defaults typically includes non-filing of Form APR or maybe Form FC, Form FLA, or misreporting of non-fund based financial commitments, closure, disinvestment, or restructuring happening under the of the step down subsidiaries, etc. Delaying reporting of setting up step down subsidiaries, non-filing of Form FCA, etc. These are kind of a reporting requirement where one just need to make a disclosure or make a filing and intimate RBI through their respective ADs in India, just to have the complete picture available with the regulator. Now let's come to the instances which classifies as the substantive default. Substantive violation will include investment in non-permissible sectors such as real estate investment, gambling, leasing activities undertaken by the overseas group entities among themselves, or Indian companies setting up overseas subsidiaries for the purpose of acquiring the immovable properties for the benefit of promoters and their families, etc. Delaying obtaining EY and non-realization of dividend, interest, or disinvestment proceeds within the stipulated timelines. So these are some of the cases, and some more instances where which will fall under the category of substantive investment. The violations will include round tripping, issue of guarantees to the second level subsidiaries, not obtaining NOC with involvement of AD bankers in India, granting loan to the step down subsidiaries. These are some of the cases which falls under the category of substantive violations. Now, while both are violation, reporting violation, as we saw earlier, are something can be curated by making a belated filing and for which now late submission fees can be paid, and those defaults can be made good. If this defaults pertains to the period prior to August 22, that is when the new OIR or extended OIR regulation rules were introduced. In those cases, government has allowed a window of 3 years, which will be coming to an end 21st August 2025, to complete the filings and make the defaults good. Whereas after August 22 onwards, whatever defaults or delays in filing will take place, those can be curated within 3 years period from the due date, again by payment of late submission. Substantive violations are those they do not uh, qualify for payment of late submission fee, and in those cases, going through the compounding process and facing the penal actions from RBI or government is the only solution to compound a contravention. This is the formula in how the late submission fee can be is to be calculated for different types of delayed reporting. Whereas in case of penal actions, the penalty implication or exposure can extend up to 3 times of the amount involved. Of course, RBI has given guidance how the penalty can be calculated in such matters, keeping in mind the circumstances or facts of the case. One important thing that needs to be kept in mind all the time, that while or till the time all these defaults are not curated, no further financial commitment or investment will be allowed in any overseas entities.
Thanks, Pankaj, for covering that so exhaustively. So, from what it looks like, substantive violations will need to be covered from by the compounding process. But as far as reporting violations are concerned, we can bucket them into three categories, perhaps. One is where there has been omission in filing the forms. Second is perhaps where there is delay in filing the forms, and third category can be where there have been misses or omissions within the inaccurate reportings within the forms. So these three categories can be regularized through the LSF route.
Right.
Right. So this seems to be a welcome move as far as the companies are concerned. At least these can be regularized without going through the compounding measures. That leads me to the second question, Suhas. Suhas, with what perspective does RBI bring in the LSF regulations? And do you see a lot of companies opting for this and rushing to regularize the non-compliances?
See, if you look at RBI as a regulator, they had been following couple of principles meticulously and throughout of the 2 decades I've seen them observing it. They are aiming toward transparency, point one, and removing the discretionary powers, arbitrary powers of levying penalty or something. Initially, compounding, if you look at compounding, was the officer's judgment, how much penalty is justifiable. Then they changed that to matrix. Under compounding regulation, they brought out matrix. But still, compounding takes a 6 month process overall. It involves a hearing, it may involve preparation of order and all that. A lot of administrative work goes in the compounding. So, for reporting delays, introduction of LSF in 2017 for FDI, 2019 for ECB, and now 2022 for ODI, it is kind of a reducing the administrative work for one hand, and second hand, making it very simple for corporate to clear the mess or clear the regularize the thing within a span of 2 weeks or 3 weeks time. Compounding takes six weeks. LSF may take 2 or 3 weeks time. LSF take. So that's the aim, and it, as I said, is moving towards transparency and much simpler method of regularizing the thing. Here is the second question you asked me is how effective it is and are the corporates taking very benefit of the scheme or not. Here, my understanding the banking industry is not many takers are there. Old kind of a defaults continues to be there. Like people have not filed APR in 2011, 12. Those continues to be there. They are not coming forward. At one stage, RBI had in 2013 given some statistics that 60% of the UN APRs were not complied in 2013. And then they came out with some harsh rules saying that if you are in any obligation not complied, you can't remit money. So that's how the LSF has evolved. But LSF, it's a good scheme, LSF, good for corporate. That's what I would say. Yeah.
Thanks, Suhas, for alluding, laying down what the objectives were, and looks like most of the corporates are approaching for compliance so that they are not exposed to compounding process. The next question, Suhas, I wanted to ask you is, it's a very practical question that we see. Many corporates have actually done outbound investments 15, 20 years back. And they find it very difficult now if any documents are missing or share certificates are missing, bank resolutions are missing. How do they now go back and remediate? It's a very practical situation that is coming up again, and people want to be compliant, but because of these unavailability of documents, there is a hitch over here.
See, the AD can guide them. Basically, here what corporates need to do. I agree with the AD banker with respect to alternate document which will give some substantial evidence. For example, if you are not able to get a board resolution copy, if you are not able to get, in that case, you can get a ROC annual return extract. ROC annual return extract has details about investment and various other stuff here. In case you are not able to get a safe valuation certificate, but you happen to have balance sheet of 2006 of that Indian entity or that entity, get the valuation done today. So various alternatives need to be thought through in terms of how it can be filled up. Extreme cases are also there. So I have seen extreme cases where a couple of corporate, their overseas JV partner wasn't cooperating with them and not ready to give financial figures of that JV entity to the Indian party, and they were stuck up in 2018, not able to file APR for 19, 20, 21 here. As an exception, we approached RBI, and RBI allowed to file APR basis the old number with a caveat saying that whenever you take legal action against the party and demonstrate that you are taking some action to regularize it here. Now, ultimately, it went for compounding, ultimately, because it was more than it's non-filing APR, it was not delayed filing APR, basically. But point here is that a solution need to be thought through in terms of alternate documentation here.
Right. So probably we can bucket this into 2, 3 categories. One is, of course, where we can find alternate documents. One is, where you may have to actually rely on duplicates, right? Say share certificates are not currently available. You may need to reissue those share certificates and provide them to the AD banker. A third category, Suhas, also comes where, RBI is very insistent, for example, liquidators report, right? That
There's alternative to that also. If you have a balance sheet of the company which is winding up, last balance sheet is there, which is certified by CPA or by chartered accountant, then that balance sheet gives you a figure of net asset value, how much is there, whatever, in terms.
Sure. But we've seen a lot of times AD bankers take a position that without the liquidators report, the the regularization may not be possible. So those are some aspects that, perhaps if it is clarified by the Reserve Bank of India in terms of what can be the possible alternate documents or what is acceptable and what is absolutely not acceptable, those will be very helpful for the companies.
See, my experience of 3 decades acting as a AD banker, I would advise my fellow AD banker saying that you don't try to anticipate what RBI will think. Give a chance to RBI to think over your position and your situation. Make a representation. Don't stop customer from making a representation to RBI. Even if documents are there, not there, give opportunity to RBI to think over it. Don't assume RBI think A way or B way.
Absolutely. So in a sense, at least the corporate should make a strong request to the AD bankers that they should seek a representation from RBI and have these matters resolved so that at least the non-compliances can be resolved.
True.
Swas, Any important practical considerations that one should keep in mind while opting for the LSF route? Anything
Say,
that comes to your mind?
I'll put it in a different fashion here. LSF, I look at like a medicine on a, and something going wrong. No? It is rectifying the damage. LSF damage has happened, and now we are rectifying it, regularizing it here. So I would take them one step backward here, and others say that you do something vaccination type, where you prepare a list of do's and don'ts. What, for example, you are issuing a corporate guarantee or performance guarantee. Uh, there's a misconception that 15 days period is there, 30 days period is there to file a document. It is incorrect. The why rules and why master direction clearly says before taking any financial commitment, give the form FC to the bank and document to the bank. So it has to be given to the bank before taking financial commitment. Number two, in case you are having evidence of submission done to AD banker in time, and you are able to substantiate that as evidence. We submitted APR in time, we submitted guarantee reporting in time. It was delayed, ABC reason, whatever, but not my fault. In that case, LSF is normally waived off. When AD Bank confirms to RBI regional office this was received by us in time, RBI allows AD Bank not to kind of levy LSF on that particular item. So that need to be taken care. Thirdly, remittances, equity and loan. I have seen yesterday only I saw one case where corporate has paid LSF for delayed reporting of equity remittances. Equity and loan remittances reporting obligation is of the AD banker, not of the corporate. Corporate gives form FC and documentation, bank process for the remittances. Once the remittance is processed, bank has obligation to report to RBI, not the corporate. So if bank has not done the reporting, corporate should not take bonus in their head. It's not their duty to report. Equity and remittances reporting is bank responsibility. Only exception here, capitalization of exports or conversion of loan to equity, those two where in it's corporate action. Banker may not assume presume it. So there it's the responsibility of the Indian party.
Right. So to that extent, then the corporates should consider, also from a timing perspective, that if they have submitted the documents, then that's the date up to which the LSF should be considered if they are delayed. Beyond
Correct.
that, it is the bank's responsibility to report it to the RBI.
True.
So as connected to this, if someone, we have seen instances, and this is again coming out of practical experiences, there are multiple AD bankers involved in one particular transaction. Suppose the transaction was undertaken by one AD banker, then the NOC was sought, but that is not available or has been misplaced. The transaction moves to another AD bankers. In such scenarios, we have seen people get stuck. They want to be compliant again, but not able to because of, multiple AD bankers and non-availability of documentation. Do you have any suggestions, recommendation for such situations?
It's a difficult one actually because it goes case to case. There's no generic answer to it. It depends on case to case. But whenever there is change in AD, 2007 to 12 one AD was there, then 12 to 19 second AD, and 19 to 25 third AD, and currently present AD is supporting you in regularization. You don't have access to other two ADs databases, whatever here. In such circumstances, the main important document which will help you is your audited financial statement of overseas company and Indian company. Audited financial statement, A, they are audited, and B, they will reflect whether shares were invested or not invested, a loan was given or not given. So having audited financial statement is important, both end, India and overseas end. And if you are able to retrieve the bank statement copy where payment has happened, these two are the critical document which will support corporate in the navigating the change of very concept. Like
Thanks for elaborating that, Suhas, because those are some practical issues that we are facing with some of our clients. And alternate documentation is what you are suggesting. Collate as much as you can and then convince the AD to approach RBI. Right. Suhas, Just can you just elaborate on the consequences if one is not able to resolve the non-compliances through LSF measures because we have maybe there are some issues and we've not been able to approach the AD banker, and the compounding process takes significant time. So in between, if there are transactions proposed, how does one go about that?
So one has to push the banker to do the calculation of LSF, and I approach the regional office of RBI to see that they give a okay within a day or two, like here. So it's really coordination between the corporate AD banker and the RBI regional office. It is in such a urgent scenario, basically.
Right. Right. So, would, taking a cue from this, say, the corporates as on 31st, as on 21st August, they were to actually make submissions to the AD banker with all the documentation and forms and apply for LSF. But the LSF, per se, the application is pending and the payment has not been made. Would that still be considered as going through the LSF route, or the company would then need to follow the compounding process because the LSF payment has not been made?
So if we are, as I understand the question rightly, you are saying that 21st August, what happens if some application is pending, payment not done, LSF, that's what they are asking.
Yes. Although the submission has been made, submission of documents by the corporate has been made, but the LSF payment application is pending and the payment has not been made.
So I'll bucket it into two categories. Category one, where you have done the regulatory reporting to regularize it. You have filed APR now, you have filed guarantee reporting now, but your LSF application has not moved to RBI regional office. Category bucket two is where your LSF application moved to RBI. It is awaiting RBI's concurrence or confirmation. So in the second category, chances are there, right, that even if it spills over on 22nd, 23rd August to get a reply from RBI, it will be considered under LSF only, not under compounding. But if you have filed document and application not gone to RBI before 21st of August, then we need to wait and watch what next stand RBI takes about after the expiry of window.
Okay. I see Shrikant has been able to join back. Shrikant, are you there?
Yeah, hi, Shirupa.
Hi,
And
sorry, you were not visible. So I continued quizzing Suhasji.
yeah, okay.
So, yes, Shrikant, then it will be great to have some of your perspective also as an AD banker on the challenges that we have been facing for some of our corporate clients. Maybe we can just take a quick step back onto some of the questions. So, Shrikant, especially on the multiple ADs involved, where there are multiple ADs involved, in your experience, how is Axis Bank dealing with such situations where files have come across through one AD, it is there with you, but the documentation from or NOC from the other AD is not available?
Yeah, thanks, Shirupa, for the question. Having single AD bank is an ideal situation, but in reality, it will not happen because corporates will be having AD banks depending upon the multiple factors like the ease of doing business with the overseas subsidiary, credit facilities available or given for that investment, or any other matters. And from the regulatory perspective also, having multiple UINs with multiple AD banks is permitted. So if you see a system like presently for exports or imports, the EDPMS or IDPMS systems are in place where the corporate can log in and view the shipping bills and bill of entry applicable or linked with all AD banks. Such architecture is not available with ODA as of now, but it's the ideal atmosphere. RBI has implemented the firm's software for reporting of foreign investments. There is no physical documents to be submitted. It can be submitted to the bank will approve, or bank will refer to RBI and all. Similarly, if a common platform or interface is available then corporates can view all the compliances related to all UANs with all the AD banks. But it's a far-fetched idea. Till the time we corporates have to work independently with all AD banks and seek quarterly confirmations as applicable. Then only they can sail through the process. As Suhas and Pankaj mentioned, LSF is a boon. Really, it's a game changer introduced by RBI. I have seen corporates submitting the applications in the last 3 to 4 years. The figures also say it's very good. The trend is good. Like if I see the statistics of the FY25, FY22 and 23, the year in which LSF has been introduced, total financial commitments from India was $25 billion. In the following year, it was almost stagnant. It was hovering around $25 billion only. In the last financial year, that is FY24 and 25, it touched $42 billion, a significant jump by 60%. If I see this financial year, last 2 months, the data is very amazing. It's $10 billion. And if I analyze the data, it will be some $60 billion. So it's very evident that corporates are willing to come forward, clear the pendencies, get out of it. And it's like a journey. They want to catch the express highway. This LSF is just like a speed breaker, but whereas compounding process is like a traffic signal. No one wants to wait at the traffic signal. They want to move. The journey wants to move on. So bumpers are okay, but signals are not good to reach the highway. And as I mentioned, AD banks and AD bank fraternity, they may submit the recommendations to RBI for the technical advancement and also some feasibility in accepting documents to clear the legacy cases.
Right. Shrikant, also your thoughts on the consequences if we are not able to resolve the LSF through the LSF route or compounding route, how does one go ahead?
Yeah, presently, the compliances are linked to the corporate and the compliances are linked to the individual UIN. If it is linked to the corporate, it is only pertaining to statement of annual assets and liabilities, which is falling due on 15th July every year. It is just 6 days away. If the corporate has not submitted, then no fresh financial commitments in the existing subsidiaries or the new subsidiaries will be stopped. But if they have something like they have 2 subsidiaries, one in Mauritius and in Singapore. Mauritius is doing well. Singapore, there are delays are there. The remittances to the Mauritius can be permitted. Like it's apt example is you have a righteous child and you have a erring child. So you permit the righteous child to go with more privileges, but the erring child, you want to keep the control and you want to supervise. And thirdly, as I mentioned, documents definitely can be resolved by reconstructing a new one or reproducing a new one. If there are any deadlock scenarios, definitely, as Suhas also mentioned, we have to consider the case by case. We have to see the bona fides of the case. We need to see the intent and effort of the corporate and also the quantity involved. AD Bank has to analyze, satisfy, and recommend the case to RBI for suitable guidance. That's the only way we can clear the pendencies and the success ratio can be improved. Recently, RBI has called the data from all AD banks, where I understand 20 to 30% of the corporates have submitted the LSF applications and they are in order. So if there is more relaxation is there or flexibility is there on certain documents where the deadlock situations are there, the success ratio will definitely improve. And we will definitely witness in the next LSF window version, that is LSF 2.0.
Right. Shrikant, love the analogies that you make.
Thank you.
But just a very important point that you highlighted. So the restriction because of non-compliance, if it is not remediated through LSF or compounding, is UIN wise. But as far as FLA is concerned, the filing is concerned, that is at the corporate level. And if there are any defaults in filing of FLAs, then the restriction essentially applies at the corporate level, and then we are not able to actually undertake any transactions.
Absolutely, yeah.
That's a great input, and I think corporates will be well advised to review their filings, both from a accuracy perspective and also from a timing perspective, so that LSF can be paid and they don't face a hitch as far as overall corporate investments, outbound investments are concerned. That actually brings us to another critical question. Swas, do you think there's a possibility that RBI may extend the 21st August deadline?
It's a difficult question to guess what RBI will think. I was earlier saying you can't guess, you shouldn't guess what RBI is thinking. But I'll answer two school of thought. First school of thought is LSF percentage, as Srikanth said, is around hovering around 20-25%. That means still 60-70% non-compliances are not regularized. If 60-70% non-compliances move to compounding, then there is a lot of work for compounding department also, RBI also, and it will be unproductive work to an extent. It will be. So from that school of thought, it may be ideal for RBI to consider extension of maybe a year or so, probably. Having said that, the second school of thought here is that RBI had given a window of 3 years to corporate, and 3 years is not a small period. I mean, corporate had 36 months to regularize it. So one may think if a corporate didn't bother about it for 36 months, what will they do in next 1 year? I mean, here. So having said that, both school of thoughts are possible. Which one RBI takes, it depends on the regulator, which one RBI takes. But chances are lesser on extension. Mostly it will go to compounding, mostly.
Right. Srikanth, your quick views on this. Have you heard from RBI?
Yeah, I echo with the views of Suhas. Well, there is a lot of work, a lot of way to go. So my opinion is one more opportunity to be given corporates, coupled with flexibility in documentation. Definitely, we can see the amazing numbers turn into complaint manner.
Okay. Cool. So, since we are talking about LSF and compounding, Pankaj, very briefly, if you can just take us through the compounding timelines. And also there is a new portal which has been introduced, the Prabha portal. So is that making any impact, and is it easing life of people as far as compounding is concerned?
So, in order to go in for compounding, the first and foremost requirement is that the contravention or default for which you are going in compounding, that has to stop. Is whatever is the non-compliance that has to be set right, and then you can go in for compounding. Compounding can be done suo motu, compounding can be done based on the instructions given by RBI. Whenever you are going compounding, you need to apply in prescribed form, make a complete disclosure with all factual and correct information to RBI in your compounding application. That application will be taken for a hearing, and based on the circumstances of the case, severity of the default, and intention of the companies, as well as the RBI guidance on calculating or determining the compounding fee, the compounding officer will dispose of the application stating the amount of compounding fees to be paid. Good part is that there is a 180 days window in which the compounding process has to be completed, and compounding fee is to be deposited within 15 days of the order. So it's a time bound process, but still it will stretch that long, and you're open to the penalty implication as may be decided by the compounding authority. Prava portal is an online mechanism that RBI has introduced to make all kinds of application, including compounding application. Entire process can run virtually at the convenience of your office and your time. Even submissions can be made online, and your order also will be issued online. In a way, it helps stakeholders in terms of making the application and tracking the progress as well. So it's a welcome measure. One need not really visit the RBI offices just to fulfill the compounding application related administrative steps. Let me put it that way.
So, from what I hear, although the process has been essentially eased, but still, in the rigors of making a complete disclosure, making sure rest of our compliances are made good, and only then we are able to approach for compounding. In that sense, it's a much more painstaking process as compared to LSF, even though it is eased at the moment.
Yes.
So, Pankaj, my last question to you is essentially, we heard all the experts over here. What would be your recommendation to your clients now as to how they should go about addressing the situation, considering that we have only 1.5 months left?
Yes. We all heard our fellow panelists, and they insisted that 21st August as of now is the last date. We don't know whether or not that will extend, but really we can't wait till the last date for making any submission. Right approach in this regard could be doing a health check of all your overseas investment, go back right up to the date of inception and see what all events have undertaken since then. What is the status of compliance reporting or filings, to the extent of filing that has been made. Making filing is not important, that filing also has to be accurate one. So you cannot just have a filing done but missing out some information or some transaction like investment, disinvestment from step down subsidy, just to give an example. So even if filing has been done, some information has not been mentioned or furnished, that needs to be updated. So health check will reveal all these gaps in terms of your compliances. Based on that, look at the status of documentation, compile all the information that you can approach your AD banker well in time to complete the filings. If you go to the AD bank upfront with all the required information, all the underlying documents, there are good chances that your application will sail through fast and your case may be submitted to RBI for LSF application is filed in time, and in any case before 21st of August 2025, by which date at least application should go to RBI so that they can consider your case for payment of LSF. So there is a bit of urgency in terms of someone really need to sit down, look at these things and verify where we stand today. Instead of waiting to the moment when someone will come and tell you, oh, sorry, you have missed on these filings, and then you start correct. Not only that, you may face problem in future when you want to kind of say disinvest from some overseas entities, or you want to go for an additional investment, and that's where your transaction may really get stuck for past non-compliances. So we do not want to line up in that situation. We do not want to face the penal actions from the regulators. We can make best use of next 4 or 5 weeks, whatever are available in hand, and comply with the reporting requirement at the earliest.
Absolutely. Thank you, Pankaj, for putting that all in perspective. I think there is action to be undertaken by corporates over there to make sure, they are compliant and they are not restricted from any further transactions as far as outbound investments are concerned. With that, we will wrap up our panel discussions, but I can see there are a host of questions which have come up. Let me see if okay. We have a question over here. Mr. A made an investment in FCO in 2020 without obtaining UIN. Consequently, no reporting of such filing was made. What would be the consequence for this? Pankaj, you want to take this?
I think what really need to investigate why UN was not allotted, because if the remittance was done from ODI was filed at that time, unless there are some questions were raised by either by AD Bank or RBI, and those were not responded or complete information was not furnished, that may be a possible reason that UN was not allotted. And if those gaps can be corrected, now this particular corporate or Mr. A can comply with obtaining a UIN now, and of course comply adhere to the direction or instructions given by RBI in this.
I'll take a further step on this. The question appears to me that A has remitted under LRS, not realizing it's an ODI, not realizing, and now UIN is not there, APRs are not filed, and what need to be done here? To answer that question, not obtaining UIN is a LSF bound non-compliance. It can be regularized by paying LSF. APR delays can be regularized by paying LSF. APR, no need of compounding, no need of. So here customer need to give a ODI form FC to the AD banker and submit a request for UIN under approval route. UIN under RBI will approve the allotted UIN. Once the UIN is allotted, do APR reporting. Once APR reporting is done, then go for LSF. Then.
Right. Thanks, Pankaj and Suhas. There's one another question. If the original form was filed within due date, but later needs to be revised due to some error or additional information, will the LSF be applicable on the revised filing? Shrikant, you want to take that?
Yeah, yes, Nirupa. The submission is treated as complaint only upon the final form. The submission of the initial form is not counted as complaint submission. So hence, the second form, which is duly complaint, is treated as a final day for submission. The LSF will be calculated accordingly.
Okay. So essentially, the latest form should be considered. The
Yes.
revised form should be
The
considered.
reverse form has to be considered. Yeah.
Right. There's one another question. In the past, prior to introduction of LSF, AD banks have condoned delay in reporting forms and the same have been taken on record. Can RBI AD bank come back and ask company to pay LSF now? Shrikant, again to you.
Yeah, we have observed some cases where RBI has condoned the filing of delays of APR and all. But presently, there are only two options, either approaching for the voluntary compounding proceeding or paying the LSF. Hence, either of the one has to be completed. In our case, since it is a delay in filing of APR, LSF action has to be completed.
Right.
Yeah, to elaborate it further here, whenever RBI condones any delayed filing, whether it is FC APR or whether it is ODI APR or whatever, there is always one disclaimer is always there in the letter. In that case, this is subject to prejudice. RBI may have right to come back to you again. Like, you know, that type of language is always there in the letter or email. That type of. So that's why even if right now RBI has condoned the APR delay, whatever, any delay, as a rightly said by Shrikant, either LSF need to be paid. If you don't follow that path, then it will go for compounding. Then.
Right. The next question is, as per RBI circular now, filing of the late filing fee application to be done before due date in case we are not able to complete the compliance. Pankaj, you want to take this? Essentially, the question is, if they are not able to make the application to RBI before the due date for LSF.
No, the application to RBI has to be filed before the due date or before the 3-year window comes to an end for payment of LSF and closure of matter. Payment can be done because after the application is filed, RBI will issue the advice for initiating the payment. So actual money deposit can happen later, but request or application has to be made before that.
Right. Okay, there's another question. If APRs for a particular UIN have not been filed for the years and also the said overseas entity has been deregistered with foreign regulatory a decade back, what's the way forward for closure of UIN for such overseas entities? Suhas?
Yeah, so here when the entity closed down, there is no APR requirement, filing requirement after the year of the closure. So if entity closed down in say 2013, then you don't need to file APR for 2014 onwards till today. But having said that, from the inception, obtaining UIN that year up to the closure year, APR need to be filed. There is no question of waiving anything. No waiver. The APR need to be filed by obtaining information.
Right, for the period prior to the deregistration.
Yeah, prior to dissolution of company.
Right. There's another question, how to notify where the parent company is waiting for WAS bank details, but the WAS has already been incorporated outside India. Usually we submit form FC with bank details of WAS, which comes under LSF. Pankaj, you want to take this? It says how to notify where parent company is waiting WAS bank details, but the WAS has already been incorporated. So essentially WAS has been incorporated, but the bank account has not been opened.
I think
What
it,
should
it,
be the
it,
course?
means, it means WAS is allocated the shares to Indian party without receiving money because bank account is not yet open. So there are cases where shares are issued in advance as a subscription share or whatever, but money is not paid. Amount is not remitted. That's what I understand from. It's a very vague question, but actually.
Yeah, so essentially what they are asking is the company has been incorporated, bank account details or bank is not open. In which case, how should they proceed?
Yeah, I will take this, Srirupa.
Yes.
Yeah, so prior to the existing framework, issuance of shares prior to remittances or issuance of the shares beyond 180 days is a non-compliant thing. But in the extent ODA framework, there is a provision given whenever an overseas entity is incorporated, it is assumed the liability has been fixed by the Indian entity. So even though the remittances are delayed, for example, 30 days, 60 days, or 90 days, maybe the reason is due to the delay in opening of bank accounts. It is clear from RBI that on the date of incorporation, you file a Form FC, that is Form ODI, earlier we call, and report it and generate a new UAN. Such reportings will happen as a non-fund based liability. When the bank account is opened, you can do a cash remittance and the reporting will change the buckets from non-fund based liability to cash liability.
Right. And Shrikant, over here, under the current regulations, there's also a provision for agreement for deferred consideration, right? So
Yeah.
The course of action should be that as soon as we incorporate an entity, we should file Form FC or even before incorporation and then enter into a deferred consideration agreement and then file the balance forms FC for the remittance from non-fund based to fund based FC.
Yeah. At the time of incorporation itself, we need to report in the portal as a non-fund based commitment. For example, the authorized capital is $100. We will report in the portal as a non-fund liability as $100. Say, for example, after 60 days, we are remitting the $100. This will shift from non-fund based bucket to fund based bucket. Then the cash remittance will be reported after 60 days again.
Right. Shrikant, one more question that I can see. Some of the companies, it is mentioned that, can reliance on project profile be considered as good, that there are no deficiencies currently?
Yeah. Detailed project profile report is the full name, but the report doesn't capture all the events. It only captures the equity remittances, loan remittances, and guarantees issued. Apart from that, it will capture the setting up of step-down subsidiaries and filing of annual performance reports. Well, it is a good start to take it, but however, as we discussed before also, there are certain omissions, there are certain misreportings, and presently there is no system to report the inflows in the form of interest, dividends, etc. So to start with, yeah, project profile is a good document to go, but corporates have to check with their respective AD banks about end-to-end regarding submission of share certificates, inflows, everything, and then only we can treat the process is completed.
Right. So complete reliance on project profile is not something that you can say that, you are fully compliant. As you
Absolutely.
mentioned, it's a good start.
Yeah.
Looks like that we have run out of time, but for those who have asked queries, we will try and reach out to you through your emails. Feel free to pour in your queries. We will continue the conversations offline amongst email. With that, we will wrap up this session. I want to thank our panelists, Suhas, Shrikant, Pankaj. Thank you for sharing your perspective. These are coming out of sheer experience that you've had working in this field for so long. Thank you, participants, for being engaged and flooding our inbox with so many queries. We will definitely reach out to you. Whoever queries have not been responded to, we will definitely reach out to you. And I hope through this presentation, you have been able to at least understand the risks involved and also ways to mitigate, strategize LSF and mitigate your risks so that your future transactions are not really impacted. With that, I would like to wrap up this session. Many thanks once again and have a good day.
Thank you.
Thank you, everyone.